Good morning to everybody listening in. We appreciate you guys joining us today. Really quickly, my name is Ray Littleton. I am an equity partner here at Foster Swift, and my practice consists of commercial litigation and employment and healthcare. I also serve as the diversity chair here at Foster Swift. And I just want to start with a couple of quick points about, why diversity is important to our company. I know a lot of companies already have their own programs and already believe that diversity is important, but just to kind of reiterate the fact, there are numerous studies that have shown that diverse employees and staff can offer different talents and experiences and skills that can help your company actually create better products and solutions. A diverse staff can see things from different angles and ultimately help to bring the best ideas together. One of the studies that I believe that's frequently pointed to, there's the Boston Consulting Group study. They actually found that companies with an above average diversity on their leadership team actually have greater payoff from innovation and higher earning margins. Diversity also helps to attract and retain top talent. As a lot of you know, each generation of new employees in our country is getting more and more diverse than the previous generation. And often people will have even multiracial backgrounds. And if you want your company to grow, you're going to be able to you're going to have to work and to incorporate this diverse generation into your company, and as well as work with clients who are diverse, right? That's even more important. You want to be able to reach your clients who are of different backgrounds and make sure they feel welcome. Diversity also helps to boost your company's reputation. You can come across as friendlier and more socially responsible. And the most important, a lot of these candidates, these young candidates, are looking at your company's diversity initiatives and your different diversity, like on your website, and just what kind of programs you have. And so I know a lot of you already, believe in a diverse workforce and, are trying to promote it. One of the things we're here today, though, is to make sure you do things in the right way. So there's been a lot of changes recently. Let's first start with last year. Our current conservative Supreme Court makeup, they had an affirmative action case presented in front of them. This was involving the admission policies of the University of North Carolina and Harvard. What happened is the law actually changed. They changed 4 decades of law regarding the ability to consider race in the admissions process. And in short, the court found that the admission policies at these schools violated the 14th Amendment's Equal Protection Clause. It's worth noting, though, that Chief Justice John Roberts did say that applicants were allowed to share how race affected their life as long as it was concretely tied to a quality of character or a unique ability that they could bring to the school. He gave an example of, if you wrote an essay on how, race has affected your leadership role or thinking. And so while that part's kind of still allowed, they did not allow for the having a race factor in the admissions process. And this lawsuit was brought by a group called the Students for Fair Admissions. It was an anti-affirmative action group that led this kind of charge that got this result. And what happened is there has been a decrease in Black student admission at these schools. I think it went from 10.5% to 7.8%. And companies were looking at this ruling, and they were trying to see, well, how is this going to play in the private sector? That's the non-academic private sector. And recently, actually, Cliff and I we did a podcast about a year ago, and then we also wrote a couple of updated articles. There's a big case going on right now. It's called American Alliance for Equal Rights versus Fearless Fund Management Fund LLC. This is a company that's out of Atlanta, and it's a venture capitalist company, and it's they have a program from their charity wing of the company that created a contest to award a grant to a female minority-owned venture capital startup. This case actually just went up to the 11th Circuit Court of Appeals, and there was a ruling on June 3rd, 2024, in which the court found that this program actually violated Section 1981 of the Civil Rights Act of 1866. So that act, and Cliff is actually more of the history buff on this and probably can give you a little bit more background about the history, but this was an act that actually came to pass after the Civil War. Congress enacted this to stop Southern businesses and individuals from refusing to enter into contracts with Black citizens. And so what happened now is the 11th Circuit has applied this act to rule that the Fearless Fund, that their program that granted funds constituted a contract that was restrictive because it was only awarding the funds to Black female candidates that, in the venture capitalist business. So, and it's interesting because, that act was actually created to prevent businesses from attacking, Black citizens who were newly free. And now a lot of these special interest groups are actually targeting minority advancement programs through the same act. And so that's kind of where we are right now. And there's a bunch of these cases that are popping up around the country where different advancement programs are being looked at. And so we want to talk a little bit about, so what are the best practices if you are trying to diversify your company and or maintain a diverse company? So I've got a couple of suggestions, and I'll also let Cliff chime in with any other suggestions for you as well. One of the ways I advise companies is to actually target maybe a region or target, economically disadvantaged areas as opposed to targeting a specific race. That's one way to where you're not restricting based off of race, but you're actually hitting a group that you probably want to reach. Another way is to always, expand your applicant pool. So look at universities that are more diverse, look at cities and areas that do have that diverse population. So you're getting candidates that of a bunch of different backgrounds that you get to select from. If you always go to the same places, you're going to end up getting the same results, right? So if you don't do anything different, you'll get some of the same kind of applicants as opposed to expanding that pool. And so that's always a positive way to do things that should survive scrutiny. Make sure your interview process is fair and not biased towards one race or another. And even something that's mentioned from John Roberts' opinion, consider life experience also as a positive factor when you're interviewing talent. So if you also want any other ideas, or if you need help with trying to increase your diversity without running afoul of some of these decisions, definitely give us a call, and we can help you kind of generate some different ideas to make sure you're reaching this next generation.
Yeah, I'd love to piggyback on a couple of those items, Ray, because what you're talking about are things that we deal with, not only on the human interaction side of it, but also on the AI side of it, right? And as we're seeing, AI replace some of those decisions, right? Whether it's in hiring, whether it's in deciding, how to downsize or right size a company, you run into the overarching issue: is your AI model adjudicating and making decisions and documenting how those decisions were made? in a way that's appropriate under the law, right? All those things that you're talking about, expanding your hiring pool, right? We've seen certain cases where AI models were, probably unintentionally, right? Although, garbage in, garbage out sometimes, right?
Right.
But they were redlining based on zip codes, right? They were looking just at pure data, as so oftentimes computer systems do. So again, I think making sure that how the AI programs are selected, how they're documented. There's a couple of points I want to make on that in a moment here, but how that is integrated into these laws is going to be an ongoing issue, and is going to require quite a bit of technical understanding, right? These AI systems are complicated. How they make decisions, how they get their data, right? Is not necessarily something that the average person, they have a passing understanding of. But if there's a lawsuit in the future, being able to explain that under the rules of evidence, and having that expert testimony in order to defend against these cases really does require a fairly substantial understanding of how the AI system came to its decision, right? Did it exclude because of zip codes and was just bad, judgment? Or, did someone, program something into it? Was there, a requirement in the job description that the AI either overtly saw or inferred that could create a problem? You even look at it with respect to, the other side of the process, right? Deciding, how to right size a company. Is AI opening yourselves up to these disparate impact arguments because they look at retirement age, or they look at the age of their workers, and coming up with some sort of mathematical calculation without taking into account these protections under the law. So it really is an interesting area that is going to require that technical understanding. And we should also note that there's a lot of states that are actually putting together laws that are dealing exactly with this issue, right? How AI is used, whether it's on an interview side, whether it's on the termination side, or the day-to-day operations. For example, I know that Colorado has some laws that are coming into play. I think it's in 2026, basically saying that the AI model has to use reasonable care, right? What constitutes reasonable care? I guess the jury of your peers will tell you if it becomes an issue in the future, right? But these models have to have reasonable care to protect from these, algorithmic decision makings, right? Actually have someone on with their finger on the pulse of how the decision is made, right? You have other laws that are out there that or require certain consents that are necessary before AI systems are used, right? I think Illinois or Indiana has that legislation that started in 2022. You also have some laws that are out there that are talking about some of the technical uses of AI, right? Using AI to model faces and things like that, and we've seen that most recently in the city of Detroit, where they tried rolling out this program to help identify people using AI, and I mean it was horrible from what we've seen as far as its ability to identify people of different ethnic backgrounds, right? Very disproportionate how those got triggered, right? A lot of bad press associated. So again, when we're looking at the implementation of AI into these DEI programs, it all comes back to, in my opinion, how we make sure to operate within the legal framework that you discussed, and how we make sure to integrate that within the AI program. And then lastly, how to make sure to document how that decision was made. We talked about record keeping requirements, in the last segment, right? Being able to show if there is a lawsuit, or there is an allegation of some sort of disparate impact or some sort of violation out there, how the AI model came to its decision, or how human intervention helped mitigate some of those issues. So again, not only do we have the legal update, but having that technological side is really an area where I think if companies have a chief technological officer, they really need to have their finger on the pulse of the HR laws to make sure that their technology is being implemented correctly.
Yeah, thanks, Rob. And this AI is intriguing because we are in the world where we have robots replacing people on assembly lines. We now have AI. The question is how far is that going to go in the way of replacing people making decisions? We have employment discrimination laws that say you cannot be biased. Ray had said we got to be careful on what we're doing to make sure we're not biased against any particular groups. And so the question that I have, and I guess I have for Tony, because I know, Tony, you've done some work on this, is can a robot or can a computer program discriminate?
The short answer is yes. So the EEOC has come out and published guidance and said very clearly that AI, artificial intelligence, whether it's ChatGPT or even software AI built into Indeed's resume scanners, things like that, that can discriminate when it's used for employment purposes. So when it's used for recruitment, hiring, retention, promotion, performance monitoring, dismissal. Companies are using activity monitoring to see the how many keystrokes individual employees are using. Those can be discriminatory. And so they've outlined a few instances specifically in the hiring process that could trigger Title VII violations. And those are resume scanners, chat boxes or chat bots on websites, video interviewing software, testing software, and again, employee monitoring software. And the big thing that you need to know, and Rob touched on this, is you can't pass the buck to the software vendor. You can't say, well, I didn't know. I'm not a tech person. We hired this software company to implement the software into our hiring systems. And, if it ends up committing, discriminatory or bias acts, you're the one that's on the hook. Now, the software vendor maybe as well, but you can't throw up your hands or put your head in the sand and say, yep, yeah, sorry, I didn't know. So, for example, an AI tool might automatically screen out applicants based on large gaps in employment. But this could be an issue or could have a disparate impact on the basis of sex, because the large gaps might be a result of pregnancy or leaving the workplace to raise children. The main case that sort of spurred the EEOC's guidance involved a company called iTutor Group. And what they did was they had an AI software screen resumes, which isn't uncommon. Companies are doing that all across the country. But what happened was the AI software was screening out unintentionally applicants who are female and aged 55 or older. So, and it was like 200 or more applicants. And so what happened was these same individuals who didn't get an interview from the company then changed their name and changed their age on the exact same resume, and boom, they got an interview. They were moved on to the next section based on the AI. So it's really important to make sure that you're paying attention to your AI tools. If you've got a chief technology officer, ask questions, have conversations with the software vendor, see if they've done any audits to see, if there's any sort of discriminatory results or biased results that may have a disparate impact on particular groups. So that's the Title VII side. Now, the EEOC has also come out and said that employers could get in trouble with the ADA by using computer-based tools. So they said there's three particular instances where you could get in trouble with the ADA. The first is failure to provide a reasonable accommodation to someone who needs one to be fairly and accurately, rated by a particular algorithm. So, for example, if you've you know, if you have to do a video interview, a visually impaired applicant, you know, should probably be given or offered an accommodation that does not require either watching or using sort of those video tools. The second area that you could get in trouble is the risk of screening out individuals with a disability, even though, you know, they may be able to perform the job with a reasonable accommodation. And then the third is you want to make sure your AI tools, if you're using them, you're not asking any disability related questions or medical inquiries such that the ADA would be violated. So you want to make sure that you're paying attention to the technology that you're using, because you can't pass the buck. You're on the hook for whatever result comes from those particular computer tools. And, you know, AI can be a really powerful and helpful tool. You just need to be involved and, you know, make sure you know what you're using.
Okay, excellent. Thanks, Tony.